Nan Stevenson joins us tonight to talk about estate planning and tools that will allow cancer patients to stay in control, and she's also going to talk a little bit about charitable giving. Nan is a seasoned lawyer in the business law field. She currently has over 700 wills in her vault and does between 5 and 10 wills per month. Part of that practice includes estate planning, and in some instances also involves some corporate reorganization and transfers of properties to achieve the wishes of her clients. Everyone, please help me welcome Nan Stevenson to the podium.
Okay, well, thanks, Kelly, for the introduction. As Kelly mentioned, I've been a lawyer for a very long time. I walked into my first law office to work in 1962, so that probably gives away a lot right there. I was not a lawyer then. I went to law school in 1979-80, and I graduated in 1983 with what we now call a juristic doctor. It was an LLB then, but it's now a JD. So I articled and worked at Bennett Jones for 7 years, and then I was on my own for 5 years, and then I was at Field for 15 years, and I left Field in 2009, and started my own firm with 2 other lawyers, one of whom then retired, and our lease was up. So I'm now in a new association that I've been with since April of 2015. So we're in the Kipling Square building just over on 10th Avenue and 5th Street. So it's not very far from here. We had pretty good parking until they started building the Marriott Hotel, and now it's a bit of a nightmare. There's lots of building going on 10th Avenue. So we do primarily business and personal services work. So personal services work would be wills and estates and those kinds of things. My other 2 partners do some litigation, but I do little, if any. If I can get out of it, I won't do it. So I like to think that I take the mystique out of visiting a lawyer. I try not to talk down to people, and I try not to use buzzwords so everybody knows what everybody's talking about it. And I think it's really important that people feel comfortable when they come to talk about their estate planning. I spend 2 to 3 days a month in seminars and continuing education programs. I send my assistant to programs when they'll help her help me. And I do try and stay current with what's going on. I go to Calgary Bar Association meetings about 4 times a month and talk about various subjects. Today it was wills and estates, and they talked about fraud. So that was kind of interesting. So my big passion is wills. I love to make sure that people are set up for whatever they need for whenever they need it. And you don't need to be sick, and you don't need to be old to need a will, enduring power of attorney, and personal directive. You could walk across the street and get hit by a bus. There's no magic. It's not, nobody is immune. So I'll give you my little spiel, and if you want to interrupt me with questions, I'm fine with that. If you'd rather wait till the end, I'm fine with that as well. So you can make all the plans in the world, but unless you write them down and have an up-to-date will, they won't happen. So if you want to make a charitable donation in your will, unless you have a will, it's not going to happen. So there's a lot of reasons why you want to do a will, enduring power of attorney, and personal directive. It's all about you being in control when you don't have control anymore. So you decide ahead of time who you want to be your executor. You decide ahead of time who's going to manage your financial affairs when you're not able to, and you decide ahead of time who's going to liaise with the doctors if you want the plug pulled. So that's basically where I'm coming from. So having a will is about having a choice over who looks after distributing will and your assets and where they go. In 2012, they brought in a new act called the Wills and Succession Act, which basically turned everything that we'd been doing up to that time on its ear. So up to then, if you got married, your will was voided. You had to do a new will if you got married. And if you got divorced, your will was still good. So what they did with the Wills and Succession Act is they made it so that if you get married, your will is still good, but you're just leaving yourself open to have for your new wife to have a claim on your estate. So it really isn't helpful. I mean, you still, in my opinion, you still need to do a new will if you get married. And if you get divorced, your spouse gets written out of the will. So I'm kind of curious to see how they're going to do that, but that's the way it is. So it's completely turned upside down from what it was before. And I find that a lot of times people don't come to see me about wills, don't phone me about wills until something happens. So someone in their circle dies without a will, and they figure out how bad it is when you don't have a will. So if you don't have a will, there's no one to administer your estate. If you have a will and you name an executor, then the banks and people will deal with you because you're the named executor. If you die without a will, you have to do what's called an administration, so there's no will to probate. So you end up with whoever is in the line of succession as your executor. So you have no choice about who it's going to be, and you have no choice about where your estate is going to go, and you have no trust for children that are under the age of 18 or 25 or whatever age you pick. So under the Wills and Succession Act, the first person who would get your estate is your wife. And if all of the children are children of you and your wife, then your wife gets the whole estate. If they're not, the wife gets 50% of the estate, and the rest of the estate gets divided amongst the children. Yes?
This is just provincial legislation?
Yes, it is. Yeah. Wills and estates are, except for the tax part, are provincial. The tax part is federal. Yes.
Continuing on that, my mother-in-law lives in Quebec. She's moving to Alberta. She has a will that she did a couple of years ago. Should she have it redone?
Yes, she probably should. Wills, by and large, across Canada require 2 witnesses in the room at the same time. And as long as you meet the formalities of the Wills and Succession Act, your will is probably okay. I find wills from Ontario and Quebec are geared to the Ontario and Quebec laws, which may not be relevant, but it may not matter. She should just have somebody look at it. Now, when you come to the enduring power of attorney and the personal directive, they are province-specific. So an enduring power of attorney that you do in Alberta may not be good in BC. Personal directive you do here may not be good in Ontario. So it's a good idea to have it looked at to see whether it still fits the bill or not. Okay, so your beneficiaries, as I said, your spouse, then your children. Then if there's no spouse, no children, it would be your parents, then your siblings, then your aunts and uncles, then your cousins. It goes down the line. And it may be people that you have absolutely no interest in getting any part of your estate. And it's the same with the Estate Administration Act, which is a brand new act. It's about 1.5 years old. And it again has turned a lot of what we always did a bit upside down. So the act now sets out what the executor has to do. And so you have to keep the beneficiaries informed. You have to apply for probate if you need to apply for probate. And it sets out all the duties. And again, it sets out who will administer your estate if you don't have a will. And again, I had a client that had a lot of money, and he got married, and that was in the days when you got married, your will was no good. And I kept trying everything to get him to do a new will. I said, well, she'll get 40% of your estate. Well, that's okay. And so finally I said, well, she'll administer your estate. And that did it. But I didn't know what the magic was, but I finally hit on it. And then he did a will, because he didn't want her administering the estate. So there's also an act in Alberta called the Adult Interdependent Relationship Act. So in Alberta, there's no statute that deals with the property of common law or same-sex couples. We have the Matrimonial Property Act, which deals with married people, but we do not have any other act in Alberta that deals with property. The Adult Interdependent Relationship Act deals with estates and with support. So if you've been with someone for 3 years or more in an economically dependent relationship, you're considered to be an adult interdependent partner. And at that point, you are the equivalent of a spouse for estate purposes. So it gives some status to, which I actually think is a good thing, because there's many people that have been together forever, never got married, and all of a sudden they die and the estate goes somewhere else. So I think that's not a bad thing, but it's something you need to know. The Dependent Relief Act has been rolled into the Wills and Succession Act, and that deals with if you don't leave enough to your spouse or dependent children, they can bring an application to get more of your estate. So when you're thinking about what you want to do, you have to bear in mind, if you have a spouse and if you have dependent children, you can't leave them out of the will. If you have an adult child that is not dependent on you, that you don't want to leave anything to, in Alberta you have the testamentary freedom to do that. In BC, not so much. They have what's called the Wills Variation Act, and there's all kinds of cases where adult children who have been on Skid Row and whatever come back and make a claim against an estate, and the BC courts are sympathetic to those claims. Not so in Alberta. We talked a bit about the Matrimonial Property Act. Yes?
Concerning executors, naming an executor, are there any restrictions in where the executor resides, if not in Alberta?
Well, yes and no. As long as it's in Canada, it's not a problem. If it's outside of Canada, it's a really big problem, because the estate is deemed to, for tax purposes, is deemed to be domiciled where the executor lives. So if you name an American child to be your executor, then you're running the risk that your estate may be administered under U.S. tax law, and you do not want that under any way, shape, or form. So it's better if your executor is resident in Alberta, but it's not essential, because if your executor is in Saskatchewan, Ontario, BC, it's still Canada, and the surrogate rules say that you have to post a bond if you don't reside in the province, but we regularly apply to dispense with the bond, and I've never had the judge say, no, you have to have the bond. So it's better if it's Alberta, but as long as it's Canada, it's not bad.
Could you just repeat what you said about posting a bond? I didn't quite get it.
Okay, so the rules under which so you make an application in surrogate court to get a probate. And so we have what's called surrogate rules. And the surrogate rules say that if your executor lives outside of Alberta, your executor must post a bond in order to administer your estate. And the reason for that is that the Alberta courts have no jurisdiction over anybody that doesn't live in Alberta. So they're kind of like the estate's being administered here, but the person lives in Ontario, and they can't force that person in Ontario to do something here. So the rules say that executor posts a bond, which is very difficult to get and very expensive. So we regularly apply, when we make the application for probate, we apply to dispense with the bond. Yes?
2 adult kids, both independent, both named as joint executors, living in different provinces. How does that get handled? Not a problem?
From the rules point of view, no, it's not a problem. From a practical point of view, yeah, maybe a big problem. Because somebody has to mop up, right? I mean, somebody has to clean out the house and do all of those things. So if you've got two outside executors that live outside Alberta, they'll have to deal with it. I mean, they'll have to do all those things, but it may be more difficult than if one of them lived here. Yes?
Does two executors cause some logistical issues around signatures?
Well,
rules?
it can, but I've seen, a number of cases where you've named one well, there was one estate I did many, many years ago, and there were 4 kids. And there was no will. So it was going to be kind of unwieldy for these 4 kids to have to do everything together. So they all decided that one of the kids would be the administrator of the estate. Well, lo and behold, he took off with most of the estate. And so they don't talk to each other. It's an ugly mess. So it's probably better if there's 2. Logistically, it's not as easy, but really all they have to do is sign the application for probate, and that can be done. We can courier it and get it couriered back. So that's not a big deal. They have to obviously deal with the nitty-gritty of the stuff. And then once the estate's probated, if it's going to those 2 kids, it's 1 or 2 checks. It's not a big deal. But the banks will insist on both the executors signing. So sometimes, one will renounce. So they'll say, "Well, you just go ahead and do it. I'm fine with that." In a second marriage situation, I usually recommend that somebody from each side of the family. Well, even when you're a couple and you die, and let's say you don't have any kids, and half the estate is going to your family and half the estate's going to her family, then it's a good idea to have one from each family as the executor, and it's just a way of kind of keeping everybody honest and knowing what's happening. So it can be a logistic issue, but it doesn't have to be a big one. So we mentioned briefly about charities. A lot of people like to leave something in their will for charities. It's a small tax benefit. It's not a huge tax benefit. But if you die and you've got a large RRSP, that money is going to be taxed as income in the year of your death. So if you have $1 million in your RRSP and no spouse, that RRSP is worth about $500,000. So you can get rid of some of that tax by giving some of your estate to charity. And if it's not in your will, it won't happen. So if that's what your bent is, it's a really good idea to have a will and make sure that happens. So just briefly, what's in your estate? So everything you own by yourself personally is your estate. So if you own a property in joint tenancy with your wife owns that property if you die, and vice versa. The will does not have to be probated in order for that property to transfer. Insurance policies with named beneficiaries fall outside the estate, and RSPs with named beneficiaries fall outside the estate. Now, the problem with the RSPs, if you're not leaving them to your spouse, your estate's going to pay the tax on the RSP, and your kid or your friend or whatever is going to walk away with the whole RSP. So there's a mismatch on the tax if you do that. So the other thing that's sorry, yes?
When you are saying about the property joints tenants,
Yes.
spouse, so can one of them say, I want, when I die, my have goes to certain place to the children, or once you die, it goes automatically?
Well, if you have a property in joint tenancy with anyone, I mean, normally it's your spouse, but it could be one of your children. So if you have a property in joint tenancy, the property by law belongs to the survivor of the two joint tenants.
Yes.
And that's the same with bank accounts, anything, a stock account, anything that's joint belongs to the survivor. So it goes outside the estate. It never forms part of your estate. So if you have an investment portfolio in your name, then that would be your estate. If it's not joint, it's your
So
estate.
if it's joint tenants, your answer is no, it goes automatically.
To the
and I
survivor.
can't, give some to my children.
No,
No.
no. Now, you can, yeah, we'll talk about that in a minute. So the other really big issue of not having a will is children. So the law in Alberta is if you are an adult at 18, and if you don't have a will, then your children or grandchildren, as the case may be, depending on what the circumstances are, will get your estate, their portion of your estate will be paid to the public trustee. Public trustee will administer those funds. They will distribute them to your children as they see fit, and your children will get your estate when they're 18. So I don't know about any of you people, but I wouldn't have been able to handle it at 18. My daughter wouldn't have been able to handle it at 18. I just think that's a recipe for disaster to have kids have a whole bunch of money at 18. So that you set up a trust in your will so that your children get the money either in stages or 25 or whatever age you think that they should be able to manage the capital. In the meantime, the money's all there. It's available for their maintenance, benefit, and education, and your trustee will dole it out to them. So the difference is that they don't get to spend it. It's available. They can, your trustee can say, well, you need a down payment on a house. Yes, your father would be happy with that, and we can do that. You need to go to university. Yes, we'll pay for that. You want a Ferrari? No, we're not paying for that. So that's the benefit of having a will and having the trust set up in the will. Now, up until a couple of years ago, people were also leaving what was called spousal trusts. So if you each had an estate and you didn't really want all the income from both estates, then you would set it up in a spousal trust. So the spouse would get the income during her life, and then on her death, it would go to the kids. It was a pretty effective tool if you had a second marriage situation, or you have two high net worth individuals and you didn't want all the money in one pot. But the government has changed that now, so that was called a testamentary trust, and they were taxed at a much lower rate. So they've now changed it so that after 3 years, a testamentary trust is taxed at the highest tax rate. So it's really bad when you've got young kids and you want to leave the money in trust for them. So the government's eating up the kids' money. I don't think that's what they intended, but there's a lot of unintended consequences with a lot of changes to the tax rules. And it's a problem. So when I do wills for couples, which is most of what I do, if one of you dies and you want the same thing to happen if both of you die, then you need to have pretty much joint mirror image wills. So you leave, if something happens to your spouse and your children, you leave half to your family, the other spouse leaves half to their family. So if it's not the same in both wills, it causes a big problem when you come, if something happens to you at the same time. As long as one of you survives, it's not an issue. And I've been doing a lot of testamentary contracts recently. So that's people that are in second marriage situations. where you want to make sure that at the end of the day, your kids get what they're entitled to and the other spouse's kids get what they're entitled to. So if you do a testamentary contract, then it's saying whatever we owned the day the first one died is the joint estate. The surviving spouse can live off that estate, but if they want to give major gifts to their kids, they have to give major gifts to the other kids. And at the end of the day, when the second spouse dies, whatever's left of that joint estate will be split amongst all of the children. It's not as good as a testamentary trust, but the testamentary trusts just don't work anymore from a tax perspective. So basically, it keeps everybody honest. They're going to, and the beneficiaries have the right to challenge if they see the surviving spouse buying big cars and houses and whatever. They can be pretty sure they're using your money, and they can challenge those things. So we talked about what is in your estate. So if everything is joint, then so let's say it's insurance proceeds, RSPs, and joint, everything, all the accounts are joint, the property's joint, then you don't need to probate when the first one dies. And all a probate is submitting the will with an application to the court to have the court declare that this is the last will, and it's a valid will. Banks, investment companies, they will not transfer assets from in one name to the surviving spouse without a probate. Real estate, you cannot transfer a property in one name without a probate. They say with joint property you can, but then when the second one dies, they'll have to be a probate. And the other thing, I just got a notice today about that's pretty relevant. So if you leave your RSP to your spouse, then it rolls to your spouse on a tax-free basis. There's no tax paid at the time that you die. But when your spouse dies, so if you had $500,000 RSP and your wife had a $500,000 RSP, so all of a sudden the survivor has $1 million RSP, and that's going to be taxed as income in the year of death of that spouse. So the changes that they've made for the higher income earners are really going to affect that substantially, even more than they do now. So, I mean, there really isn't any way around it, but it's just a fact that that's what's going to happen. Yes?
What's the status of the TFSA when?
So, with a TFSA, again, if you roll it to a spouse, so it's called a successor holder, and if you name your spouse as your successor holder, then your tax-free portion and her tax-free portion will continue to grow together tax-free. If you leave your TFSA to a child, then your tax-free portion stops the day you die. So anything that's earned after you die then becomes taxable as income.
So there's a tax advantage to leaving that TFSA to your spouse.
Oh, definitely. And, you know, I think, TFSAs are still pretty new, but I think it's going to be a major tax planning tool in the future. Because I think, what is it, about 55,000 you can have now? I'm not sure what the amount is. But, you know, once you start taking out of your RSP, it's very expensive. I mean, the tax is huge. I mean, this whole theory about when you start taking it out, you'll be making way less money, just isn't a fact anymore. I mean, people are still working, and they're forced to take this money out, and they could live, 40 years, and the RSP isn't going to last that long, unless you can save it when you take it out, but, you've already paid a bunch of tax on it. So I think we got sold a bill of goods, but it was a forced saving, and that's the only thing that was good about it. It did force you to save. Okay, so when would you renew your will? Well, there's no magic. It's not 2 years, 3 years, 5 years, 10 years. It's really whenever your circumstances change. So it's a good idea to be looking at it to see, maybe I don't want this executor anymore. Like I got a phone call today and said, get rid of those executors and I don't know who I want. So I have to call them back and say, well, yeah, we have to decide who you want. But that's a common one, that, you know, well, I don't want that person. Maybe they've seen them administer somebody else's estate and they decided, no, I don't want that person. Yes?
Still on the question of an executor, the responsibilities of an executor, depending on, of course, on the assets, can be quite onerous. There's a lot of stuff that has to be done.
Yeah.
And I'm wondering what your thoughts are in terms of naming a financial institution as a co-executor. You know, you can do that for a fee, and they will look after certain aspects of, of the estate. For example, you know, somebody has to file a final tax return.
Yeah.
Well, you know, unless the person who's the executor is comfortable doing that.
Well, so the executor doesn't need to be able to do every single thing that needs to be done. The executor is responsible and in charge of liquidating the estate and distributing it to the beneficiaries or setting up the trust, whatever the case may be. That's the executor's job. So if he needs financial advice, investment advice, legal advice, accounting advice, he doesn't have to know how to do all of that. He has to know people to ask how to do it. But I always tell people it's not an honor, it's a job. And it can be a very big job. If you've got a complex estate, then it can be a big job. Corporate executors charge a lot of money, but there are definitely situations where that's the best choice. I mean, I had a couple whose kids do not get along. Like, there is no way in God's green earth that those two could have ever administered the estate, and they couldn't name one of them. So they did name a trust company to do it. The trust companies, naming a co-executor with a trust company, I don't think is of much advantage. The trust companies just do what they're going to do. And I mean, it may be, you know, if there's kids that need to get money or whatever, there may be an opportunity for co-executorship, but they charge the same money, whether they're co or full executors. And you know, as I say, there are definitely situations where it's a good idea. For 90% of the people, probably not. But you are saddling someone with a very big job when you name them as your executor.
The executor is entitled to
Compensation, yes.
compensation.
Yep. Yeah, under the rules, they are entitled to compensation, and when I do a will, I usually, if it's not a beneficiary that's the executor, I'll put it right in the will that they can take compensation. But by law, they can anyway.
So in the will, do you set out what is the percentage, depending on the size of the estate, as a compensation to the executor?
Well, there's a schedule that the court uses. It's not law, but there's a schedule, and there's a range of, for each job that you're doing, there's a range of a percentage that you can charge. So yes, it does depend on the size of the estate. I mean, what some people do is they'll leave the executor $10,000 or $20,000 if you say it's in lieu of compensation, they're going to pay tax and they're going to pay GST. So you don't do it that way. You would just put it into the will that says, if so-and-so is acting as my executor, they're to get $10,000 or 20 or whatever the number is.
And would that still be their income, or now?
No, it's a gift.
Now it's a gift and they are exempt from
Income tax, yes. Yeah. But if you leave it if they charge an executor's fee, they pay tax on it. And actually, I had one, I really couldn't believe this. This woman was an executor of her friend's estate, and so she took a fee, and it was a huge job that she did, so she was perfectly entitled to take a fee. So she paid tax on the fee, and then they came back, now she's already collecting CPP, they came back and made her contribute CPP on that executor fee. I was just like, really? I can't believe this is actually happening.
There's no getting around it, right? Once they
No,
determine that she owes it.
no, that was it. Like, it was just, I had never heard of that, or never even thought about it. So anyway, when you would change your will is when there's a change in your circumstances. So either you become very wealthy or you become very poor. There's new, births, deaths, those kinds of things will trigger. I had one couple, I did their wills when they got married, like 30 odd years ago, and they had one kid and no money. They now have like probably $7 or $8 million, a kid with issues, and they still haven't changed their will. I keep telling them, it's no good, it's bad, bad, bad. It was good at the time, but it's not good now. And that's the thing, is you do a will for what your circumstances are today. So if your circumstances change, so as I say, you get really wealthy, well, having your estate go to your kids at 25 is not a good idea anymore, because at that point it was $100,000, now it's $3 million, and you don't, and if you've got any children or grandchildren with any kind of disabilities that are going to be on AISH, that's the Alberta government for severe handicap, income for severely handicapped. You can totally wreck all of that by leaving them a bunch in your will. So if you have any kind of issues like that, it's really important to have a will. So any questions on the will? Yes.
This has nothing to do with the will, but if you, like as a couple, you have a house, and you know in the future you won't be able to live in the house, so you have to go into a lot or whatever you go to, would it be an advantage to deed the house, or can you do it, deed the house to the children while you're still alive?
Well, you can, but so that's a very common tool in BC and Ontario, where they have very large probate fees. It's really a tax. They call it a probate fee, but it's really a tax. So that's a very common tool, and I don't like it because you're then subjecting your property to your children's marital situation, bankruptcy, and you lose control. You cannot deal with that property unless they agree. So I'm not a big fan of doing that, and in Alberta it's never been a big issue, because even today, the probate fee, if your estate is over $400,000, the maximum probate fee is $525. So to me, it's not worth taking that chance that you could lose your house because your kid went bankrupt or married somebody that wanted to take half your house or whatever. Now, that's the situation today. Who knows what Rachel's going to do? I think, it's an obvious to increase the probate fees. The Conservatives increased it by $100, which was still nothing. I don't know. Like right now, it's not, in my opinion, it's not a good idea. If you're at death's door and you're not going to live in the house anymore, and you're the last one, well, yeah, sure. But that would be about the only circumstance that I would suggest doing it in. Yes?
My last question.
Oh, it doesn't have to be your last question.
My daughter is engaged. She's been married. She has not been married. She's been living with her boyfriend for 4 years. They both have jobs. They're not what you would call one being dependent on the other. How does that affect the common law?
Well, as I say, in Alberta, there's no legislation that deals with property of common law. Yep. So, well, it gets a bit complicated because if they bought something together, then that's going to be a joint asset, and it'll be probably deemed to be 50-50 unless they have some agreement that says I put up 80% of the money and you put up 20. And on a split up, people tend to try and divide the property the same way as if they were married. But totally depends on what everybody did. Because the only way that you can get at your common law spouse's property is to claim that it was because of what you did that they were able to make the money, buy the property, buy the investments, and that you should have a share of them because you were involved in making that happen. Not necessarily contributing money, but you stayed home and looked after the kids and made it possible for the wife or the husband to go out and work and earn all this money, and they put everything in their name. So there's a number of cases dating back many years that give common law spouses a constructive trust. So I stayed home and I did all of this, or actually, I was actually helping you in this business, and you put everything in your name. Well, that's not fair. You've been unjustly enriched by what I've done. And even to this day, in Alberta, that's the only argument that a common law spouse has to get property of the other spouse.
But her property stays with her. If they don't go through this, they say, okay, we're about even, forget it. So her property would stay with her, and his property would stay with him.
Yeah.
And it just stays like that.
Well, assuming they don't commingle and, assuming she doesn't stay home and have babies and...
Well, not yet, anyway. As you say, current situation.
Yes.
Yeah, my wife and I have a will in Alberta, but we snowbird in the States for 4 or 5 months of the year. If we were to die in the States, would there be any problem with the will in Alberta?
No, I don't think so. As long as your residence is here, it doesn't matter where you physically die. It matters what your residence is when you die. So if your residence is Alberta, then you'll be governed, your will be governed by Alberta law. But if you have property in another jurisdiction, then that property has to be dealt with in that other jurisdiction. The Alberta courts have no ability to deal with that property. Okay, so I'll just talk briefly about enduring powers of attorney and personal directives. So as I said at the beginning, I don't think you have to be old or sick to need those documents. So the enduring power of attorney deals with your money in a situation where you're not able to communicate what it is. So you're in a coma, or you've got dementia, or whatever. So, and there's 2 kinds of enduring powers of attorney. One's called a springing power of attorney, which only comes into effect if a medical doctor or 2 medical doctors or however many people you say that you're not capable of managing your own affairs. The immediate power of attorney comes into effect right away. So you don't have to go through having the assessment, getting somebody declared incompetent in order to bring it into effect. So without the enduring power of attorney, if you are in the hospital in a coma and somebody needs to be able to pay your taxes, pay your condo fees, et cetera, then the only option they have is to go to court under the Guardianship and Trustee Act and get you declared incompetent and them named as the trustee. It's very expensive, it's very time-consuming, and it's not worth not having an enduring power of attorney so that can happen. So the person you name as your attorney in the enduring power of attorney, it's not lawyer, it's that steps into your shoes and acts. Normally you would do it each, spouses each for the other, and then you would name another person in the event you couldn't do it for each other. So it could be a child, it could be, if you're having a trust company administer your estate, you could name the trust company again for a fee. A lot of times people name whoever's going to be their executor as the attorney. And again, you run into the same situation because the person who is acting as the attorney can do whatever you could do. So they could sell your house, they could convert your RSP, they can do whatever you can do with money. So it's pretty important that you totally trust that person. And again, you may want to have two just to keep everybody honest. Like I'm dealing with a situation right now where the son, who lived in the States, had the power of attorney. And the daughter, who lives here, is the executor. So the father died, and we now have the bank statements. And they're pretty interesting. So, again, if there had been two of them, that might not have happened. If they both had to sign the checks, it wouldn't have happened. So there's definitely some advantages to having a second person. It's really inexpensive to do a power of attorney, and the alternative is degrading and expensive. Like you just don't want to have to go through that. So the other document that I like to do is called a personal directive. So in the old days, we would have called that a living will, but there was never any legislation that dealt with a living will. So in Alberta, they call it a personal directive. In Ontario, they call it the Substitute Decision Act. So every province has a different name for the same document. So the personal directive deals with your health care. So you would, again, if it's a spousal situation, you would name each other. And then you might name all of your kids to do it, or a friend that you trust, and it has nothing to do with your money, so it doesn't have to be the same person as is dealing with your money. And again, it's not expensive to do that. So I'm sure a lot of you have heard about the Carter decision, which deals with doctor-assisted dying. Right now, the way the law is, if you're completely competent the day you decide to have a doctor-assisted dying, you can get a doctor-assisted dying. If you're not competent, you can't. So right now, there's no ability to have an advance directive. So if you're saying, so first of all, in the personal directive, you're basically saying, if I'm going to be a vegetable, don't be hooking me up. Don't keep me alive just for the sake of keeping me alive. So you're making an advance directive saying, this is what I want in this situation when I can't communicate. So I'm now putting in my personal directives that I know the law in Canada isn't this way yet, but if it becomes that way, if I'm in this particular situation, then I would like to have doctor-assisted dying. Again, it's not law yet, but I think it will be. I mean, it's just a matter of time before somebody brings another case to the Supreme Court and they say yes. Because right now, it applies to very few people. I mean, if you've got MS or Lou Gehrig's disease, I think that's about the only people who would be competent in that state that could direct it. So, any questions? Have I gone way over time, Kelly?
No, you haven't gone at all.
Okay, well, I'm happy to answer any other questions. Yes?
I've served as an executor a couple of times, and my wife served as an executor for her mother. I got different advice than my wife in terms of how one, as an executor, puts their name onto the accounts that they're managing. And in my wife's case, which I had to deal with because I do the internal family accounting, the tax people basically ran their computers and found that there were some statements that were missing in terms of declarations relative to income tax. And the issue was that In the case of my wife's situation, the trust company advised, oh, we'll simply put all the money into your name, my wife's name, and the sister's name, who were co-executors. So in essence, they were getting advice that suggested that, to the government anyway, that they were the ones that were receiving the income, as opposed to the estate.
And that's another issue with putting property in joint tenancy with your kids as well. I mean, there's that whole principal residence exemption thing. So I find, mostly the banks say, you know, you can open an estate account and you can put money into that account, but until you have a probate, they won't let you take any money out of that account. They'll pay the funeral bill, they may pay condo fees and taxes, but you can't disperse any money until there's a probate. I had one estate where the executors went to the bank and they opened the account in the name of the two executors long before we had probate. Like, I'm going, I can't believe they did that. I mean, it's just, and one thing I didn't mention, as an executor, you're personally responsible for income tax and creditors if you don't advertise for creditors and if you don't get a clearance certificate from Canada Revenue Agency. So you do not, if you're acting as an executor, you never want to distribute all the estate until you have that clearance certificate. But you can't control what some banks do. It just, it boggles the mind. I hear stories that, really? That's not what's supposed to happen. Yes?
In an average or typical, whatever that might mean, sort of situation, what's the normal time period that you'd expect?
To get a probate?
No, to get the whole thing settled and distributed, signed off, sealed, done.
Well, it depends how efficient your executor is, to start with. So most wills say that somebody has to survive for 20 days or 30 days until they take the estate. So in those situations, you can't submit the application for probate until that 30-day period has expired. So then from then, it takes, so assuming that on day 31, everything was done and you were ready to file the application, in Alberta, in Calgary, it's taking 2 to 3 months to get the probate. Now, if you've got a house and you've got an offer on that house, then the court will speed up the probate. You can probably get it in about 2 weeks. But the normal is 2 to 3 months. So once you get the probate, then the executors instruct the investment houses or whatever what they want done with the money.
But you still have funds that you need to retain in the event of final income tax filing.
Oh, yeah. I mean, you're not going to be...
Suggested you withhold some money just because of this, that, and other. So by the time you finally say, okay, I think I'm totally clear of the entire process now.
It's probably, to get the tax clearance certificate, it's probably 2 years from the date of death. Yeah. They're very slow, and they look at everything. Absolutely everything. Yes?
Does a life insurance policy payout, does that have to go to probate too?
No, if you have a named beneficiary on the life insurance, it goes directly to that person. And at this point, there's no tax on the life insurance either.
So if like Matt and I, if we both have a life insurance policy and we both die in an accident, or so what happens to those two life insurance policies?
Do you have alternate beneficiaries?
Well, we have 2 children and
Yeah, so they're the alternate beneficiaries? Yeah. Yes?
What are the circumstances where an estate does not go to probate?
An estate, well, in the situation where everything is joint, it will not go to probate. It will when the second one goes, but when the first one goes, there will be no need for probate. If you've got a very small estate, like maybe $10,000 or $20,000 in a bank account, you can usually talk the bank into releasing that to the sole, and usually the case would be a sole beneficiary, like a one daughter, she's the executor, she's the beneficiary, and you can sometimes talk every bank has their threshold, but it's about 20,000 for most of them that they'll release without a probate. Does that answer the question?
We didn't do it that way.
Oh. Well, if it worked, that's all that matters. Okay, so with no more questions?